This is Michael Cowen, and welcome to Trial Lawyer Nation.
When the jury panel comes into the courtroom and the bailiff says, "All rise," I know we're here.
And it doesn't matter who they are, nobody should be above the law.
A lot of us talk about that, but you've actually done it.
That's how you also maintain quality control over your practice.
Yeah.
That's a question I get asked a lot, and here's the answer.
Welcome to Trial Lawyer Nation, your source for guidance to win bigger verdicts, get more cases, and manage your practice. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Today on Trial Lawyer Nation, I got my partner Malorie Peacock with me again today. And based on questions that you all have sent in, we're going to talk about damages, specifically how to prove our clients' harms and losses at trial. How are you doing today, Mallory?
I'm good. I'm excited to be back, of course. And I'm excited that the listeners submitted questions, which I always love.
It's nice to know someone's actually listening, yeah.
I think we'll just start at the beginning of the questions and kind of work our way through. We got quite a few to talk about today. So I think the first one is a really interesting question, and it's based sort of on maybe kind of an old school thought about valuing cases and valuing injuries and harms and losses. And so the question is 3 times the medical bills what you typically use to determine damages, or does that only apply in certain cases? So do you have any thoughts on that?
Yes, I do. No, it's not. That's actually what I was taught when for soft tissue cases when I first started practicing law, is that, you got at least 3 times the medical bills. And back in the 90s, insurance companies used to actually pay you on like a chiropractor-only case 3 times the medical bills. That's not today's world to start with. Insurance companies, unless it's a good case, will not talk about the 3 times meds. And if anytime an insurance company or a defense lawyer talks to you about 3 times meds, it's because your case is probably worth a lot more than that. But really and truly, if you think about it, what a case is worth is based on, what would a jury likely do? A jury is very unlikely to take the medical bills and multiply them by 3. Rather, they're going to look at each element of damage, and they're going to find, what they feel compelled to put in each blank. So I think you really need to look at, what are the losses and harms your client has suffered? What is the pain? What is the mental anguish? What is the impairment? Or whatever the measure of damages is in your state. And then look at, are there any what I call piss-off factors? Is there anything the defendant did, or maybe the defense lawyers are likely to do, that are likely to motivate a juror to give full justice and keep those numbers as high as they can? On the contrary, if your client's not very likable, or the defendant is super likable and their lawyer's going to be really nice, and it was a simple mistake, the jury may not be as motivated, and you need to keep that in mind when you're valuing the case.
So do you think that the jurors pay attention to the percentage of fault on the plaintiff and the defendant when they're actually awarding damages, even though they're instructed not to consider that?
Absolutely. I think that jurors, even though they're told don't consider the fault, if they put 50% of fault on the plaintiff, they're likely to then reduce the damages by half, even though that means you get, at least in Texas, a double doozy. You'd get your damages cut in half by the jury and then again by the judge because they put 50% and you only get 25%. I think, in cases of comparative fault, you have to really work hard to message that. If the judge would allow you to tell the jury, look, it's going to get cut here, so you don't need to cut it here, it would be great. But in Texas, you're not supposed to tell them the effect of their answers. So, if there was an objection, you might not be able to do that. But yeah, unfortunately, I do think that jurors, I think they're more likely to follow the law and award full damages when there is aggravated liability, and I think they're less likely to follow the law when your client has fault.
One of the important things that you mentioned, and I think that this really goes to answer the question of whether 3 times meds is how you calculate damages, is there's a bunch of other blanks on the jury charge other than medical bills. And I think that, you have to work hard to prove up those other elements. Medical bills are obvious, right? You have the medical bill, here's what it is, here's the amount that it is. So you can, nitpick about that a little bit. But the other ones, the non-economic damages, are much harder to prove up. And I think that kind of goes into our next question that we have from a listener is, what do you do to work up damages? And, it's kind of a separate question, but if you have a smaller case that doesn't warrant paying experts or spending a lot of money on exhibits or all that kind of stuff, do you do something different to work up damages?
Actually, what works to work up damages, in my experience, is not the experts. Experts are good for calculating, a life care plan if you have a lot of future medical, calculating a vocational loss. But if we're talking about the human damages, the non-economic damages, I think that people other than your client who can come in and talk about your client's harms and losses, to what your client had before, what they went through, what they're like now, I think that is what drives damages. That doesn't cost any money, but it takes a lot of time because it means you have to, and I think we're going to get into it a little later today on our plan, what all you have to do, but it means you have to go there, you have to talk to people, you have to get photos of them doing the activities of things before, maybe photos of them in a different situation after. Are there any videos? And it just takes a lot of time to develop the harms and losses. Now, of course, the amount of time you can afford to dedicate is proportional to the size of the case. But even back when I was doing chiropractor-only cases, we were getting better results than other people, which is how I was able to build up to doing bigger cases, because I did take the time to meet the friends and family members, find out their stories, bring people to tell the story, and it made a difference sometimes. And when you get verdicts other people don't get, you get better cases. What do you think?
Yeah, I think that we're going to talk about this a lot more in the second half of the podcast today, is about how you find those people and how you find the right people to testify, because just because you have a lot of people doesn't mean they're the right people. Not everybody's a great storyteller. Not everybody understands what you're trying to do. And so if you start with a list of 20 people, you might have 3 or 4 that could actually be presented at trial. But we'll talk about that in a little bit, about how kind of a method to go about doing that.
Yeah, well, I will say, though, that even when you don't find a lot of people, going through the work of learning your client's case, learning their life before, learning the harms and losses, makes you more authentic. It comes through when you really know and believe something. It comes through at trial. And I had a case once, and my poor kid, he only had his brother. That was the only witness we had for the trial, and his brother was a horrible communicator. But after going to his house, after meeting his mom, who could not communicate, she was a heavily medicated schizophrenic, he was a single mother, that's who was raising him. It explained a lot of the problems we had with the trial, but why he didn't get other medical treatment. We had a poor kid that had just turned 18, lost his Medicaid, is in the world trying to figure out what's going on. Mm-hmm. And I think the way I felt for him, the emotion communicated to the jury, and we got a really good result in that case. So we got like $94,000 on one ER bill, and like $1,500 and like $3,000 in chiropractic treatment. Probably never happened again, never happened before. But I think the way I felt for him and how much I felt for him, I think communicated through, and I would only get that because I went to his house, because I met his family and spent time with him.
Mm-hmm. Well, and all of our clients are much more than just their injuries and the physical injury. There's a lot of emotional and psychological damage and injuries that happen because of physical injuries. You don't have to have injury to your head or a brain injury or something like that to have psychological harm because you were badly hurt in a car wreck. Or even, like you said, even with a chiro bill, it doesn't mean that you're not badly hurt and it hasn't affected your entire life in different ways.
Right, and we talk about, Rodney Jew has his hope dynamic. What did you love to do before? What are you left with afterwards? How do you hope to be better in the future with the jury's help? There are things that don't require a bunch of medical treatment, but can really, really, really mess with the things you love. If you've got a guy that was a marathon runner, he may not need surgery to his knee, but the doctor might say you can't run marathons anymore. And, some people might say, well, he can still run a 5K, so what? But, your dad's a real marathon runner. If your dad couldn't run marathons anymore, that would be heartbreaking for him.
Yeah.
And so it's just, finding, but you wouldn't know that by looking at medical records. You'd have to get to know him. And I've never been to your dad's house, but I bet there's medals somewhere. I bet there's photos somewhere. If that's really an important part of someone's life, you just get a feel for someone's life by being at their home.
Right.
Okay, this is what I'm going to throw it to you this time. So,
okay.
Someone wrote us. They have a wrongful death case, and their only damages are loss of consortium. So I guess they don't have an economic loss claim.
Okay.
How do they determine a number, and what advice do you have for discussing that number with a client?
Yeah. I mean, determining a number is so difficult in all cases, but in death cases even more so, because of course no amount of money ever will replace the person that was lost. And having that conversation with a client is one of the toughest parts, I think, of our job, is telling someone that we have to put a number value on someone's life. And it's not an easy conversation to have, but if there's no economic damages, the loss of a person is, it's just it's really whatever a jury would do that day, whatever 12 people you get on your jury. And the best way to figure that out might be focus groups. But again, focus groups aren't predictive. So you can't say just because this one focus group said it's $100,000, that's what it is. Or this focus group said it's $8 million, so that's what it is. There's no...
I agree with that, but if you do a series of focus groups, and this is when you have a death case, and you have a death case where you're having to worry about value. So apparently, if you have a death case, unless you have major problems with it, it should be worth well over $1 million just for the loss consortium, I think. So you're in a situation where you have a death, you have more than $1 million in insurance coverage. You can afford to take the time to do multiple focus groups, to do jury research. And again, other verdicts aren't predictive either, because every case has facts that are different. And I think, on the wrongful death, I think, again, liability really drives the damages. I think if you have a defendant that did something bad, that they knew about a danger, they violated regulations or rules, as opposed to, someone that just made a mistake, I think they're more likely to award more. And at the same time, you have a real tough liability, and those are the conversations I hate. Mm-hmm. When you have to tell a widow or parents that lost a loved one, or children that lost their parent, there is a more likely than not chance we're going to lose this case, so we need to settle for X. And it's not a fun conversation, and trying to differentiate, which you and I can do as lawyers, but it's really hard to do when it's your family member, the difference between the value of a human life and the value of a case, which, has liability facts, has insurance coverage limits, and all that stuff in there. And again, I think you can't just have that conversation out of the blue with someone you haven't met before. I think this is another part where getting to know the client, spending enough time with them where they believe that you do care about them, that you do understand them, and you build up that trust, allows you to have those conversations. And on the contrary, going to trial sucks for the family in a death case. They are reliving the most painful experience of their life. They're like pulling off the scabs and reopening the wounds. And I think we have a real responsibility to make sure that we're doing the right thing, that the offer is not sufficient, that we're more likely than not going to get them more, and that they're willing to undergo that painful process for that chance. And it's our responsibility to make sure that, they make an informed choice. And it's always their choice, right, but that they make that informed choice.
I think getting to know the client, especially when you have to talk to them about value and understanding what their goals are and what means a lot to them in the case, what is the thing that's most important to them about their case, or about their life in the future, can really color the conversation about money. So if you have a widow that's worried about, she has this house payment and she has, this car payment that she's never going to be able to pay off and on her own. If there's a case because of liability facts that has less value, sometimes talking in those terms that, hey, this is never going to make up for it, but maybe we can do something to help you, sometimes that helps. But it's only after you've really gotten to know them and know what their struggles are and know, where they're coming from. There's always those people too where it's the principal plaintiffs, right? The people that feel like no amount of money is ever going to make it right. We want to go to trial to prove to them how terrible this was. Having the conversation with them about how terrible trial is going to be for them is an important responsibility that I think attorneys have.
Yeah, and I think there's nothing wrong on a good liability case if your client's fully informed, trying that principal case and seeing what the jury does. I think that is a perfectly acceptable function of the jury system to promote safety, to right wrongs, to give people their day in court. It's just when there are coverage limitations where every dollar you spend in defense costs, our expenses, is going to diminish their recovery.
Right.
When there is a significant chance of a comparative fault or a no liability defense, I just think we need to make sure that they're really well informed, especially if there's a decent offer on the table. Or if you're going to say it like Texas and you just feel like maybe there's a number at which you're unlikely, there's a number at which an appellate court may be especially motivated to look at the record very closely to see if there's any error. I guess that's how I'd word it. And you start approaching that number or maybe exceeding that number. You and I were in a situation where we felt like, and our referring lawyer definitely felt like we were already above that number as we were approaching trial, but we also felt there was more money on the table if we pushed. And so those are some interesting ethical and professional quandaries we get into.
Yeah.
Since I know defense lawyers listen to this, I'm not going to give the number, I think. I do think it's gone up. I think in Texas, at least, our Supreme Court has gotten more balanced. And lately, I think part of it may be changes of personnel, part of it may be they felt like they've done enough, and part of it may be that it's gotten back to them that defense lawyers call them the home office and go to mediations and say it doesn't matter what a jury does, the Supreme Court's in our pocket, and maybe the Texas Supreme Court's tired of people saying that about them. But I have noticed that, in Texas, I don't know about other states, there are more verdicts being affirmed, and the Texas Supreme Court actually is like reversed in favor of a med mal plaintiff, which never would have happened before. Affirmed verdicts, which wouldn't happen before.
Yeah.
So, if you're a defense lawyer listening, don't be so confident.
One interesting question is how you prove up loss of, I guess this is assuming there's no economic damages, this question, and it's just pure loss of consortium damages. Proving up grief is a really challenging aspect of proving up the death of a loved one. And part of that is ultimately, I think that jurors think everybody's going to die at some point. You're going to have to deal with grief of losing someone at some point. But there's a difference between losing someone expectedly and losing someone unexpectedly. And there's a difference in that grief.
And there's a difference between someone dying when it was their time and someone dying when it's not their time because someone else did something wrong.
Right.
Proving grief is so challenging. And I think one thing is, we can't just torture our clients. I was in a trial once and someone was asking the plaintiff, the widow, and so how does it feel at Christmas when he's not there? And when it's your kid's birthday and you're singing, happy birthday to your kid, and you realize your husband's not there, how's that make you? And the widow's just bawling and bawling. And the lawyer is actually playing with his glasses and showing no empathy. And I think the trial was lost right there. I think that there's a danger to just torturing. You could make a widow or any loved person just cry. I think you risk turning off the jurors. I think you expose them to that much pain at once. Their natural defenses are going to come up. So I think it really helps to try to focus on the good times before and the hope for the future with the plaintiffs, and really try to bring out the grief through other people. I think this is a time when I believe in experts. Get a grief counselor, get a psychologist to do an evaluation and let them talk about not only the grief this person is going through, but the grieving process and the natural psychological reaction. And like we said, how losing somebody in a tragedy, because someone else was at fault is different than losing someone due to cancer, which still sucks. I went through that with a loved one last year, 2 loved ones that last year. And it does suck, but it's not the same as just, you have time to prepare for it. It's different. But having someone explain that and, having other people talk about she's not the same anymore since her husband left. These are the things I've noticed, and, or maybe have them talk about each other's grief. If you don't have as many non-family members that know about it rather than their own.
Right.
Plus, even when it's not whining, no one likes a whiner, if that makes sense. Even when you have every right to feel that way, nobody wants to hear you say it. They want you to be the tough one. What was it that Jesse Wilson said? Like, the most powerful thing is not someone crying; it's someone holding back the tear and fighting to not cry. So,
yeah, that's true. I think with in life, when I think one of the most moving things is seeing people hold back tears. I mean, that's that's tough. But it can't be fake. I mean, that's if the person is an emotional person and they're a crier, I mean, it is what it is. You're not going to change them.
No, you can't. And there's nothing wrong with crying per se. It's just that the strategy is, I'm just going to put my widow or my parents or my kid up there and just have them bawl and bawl and bawl, and somehow they're going to feel sorry for us and give us a bunch of money. That doesn't work. And I would much rather have them talk about the happy times and show pictures and show video, and then have the grief counselor talk about how devastated this is and how heroic they are in fighting it and trying not to show it. But and then having other friends, family members, teachers, coworkers, someone else talk about how they're not the same, and let them talk about that loss.
Yeah.
And to me, the bigger loss really, I know every state is different, so we're just talking about the loss consortium. But in Texas, at least in some states, you get the loss of all the positive benefits that you had from the person, not just your grief afterwards. The grief is like more mental anguish than the consortium. So, having them talk about all the positive, showing why is the world a worse place because this person is no longer here? What are all the wonderful things that you all did together? What were the joys they brought to your life? Why did you love this person? What was it about them that was lovable? What did you do together to show each other the love that you had for each other? I think that is so much more powerful, and it's not seen as manipulative, because I think that tears are real, and people are going to cry in a death case, but I think people also feel like they can be manipulated, and I think you have to be really careful with jurors where they don't just turn off because we're just putting our people up to cry because there the lawyer goes again. They're just trying to get me to feel sorry for him.
Yeah. So we had a listener pose a question that they have a case where one of their clients has had 2 surgeries. It doesn't say what kind, but 2 surgeries, and is on Medicaid. So their medical bills are under $10,000. They're going to trial, and they're thinking about not submitting the medical bills for reimbursement at trial. So what advice do we have on this?
And this case will make sense to people in some states and not to others. In Texas, and I know a lot of other states, we have what's called the paid or incurred rule. So you get to submit the lesser of the medical bill that the doctor charged, or what actually got paid, subtracting whatever got written off. Like it's paid and still owed after the payment. And so in case of Medicaid, it's tiny. Texas and many states are like that. And so I'm going to throw it back to you, Mallory. So have you had any... what's your experience in whether or not, when the medical bills aren't very high, you should submit them?
So we have done this, and we chose not to submit a hospital bill for a badly broken leg that, she went to the hospital, had surgery, and then didn't really have much follow-up care. It was just a badly broken leg. There wasn't a lot that could be done for her. It was what it was. So the medical bill was very, very small. Maybe, I don't even remember what it was. And we decided, you know what, we're not going to submit it. And ultimately, we got a really great result without submitting it. And I think that part of it, I think they refer to it as anchoring. You give the jury a low number, and even though the jury isn't multiplying the medical bills by 3 times, they're thinking that somehow pain or impairment is related to whatever numbers you give them. So if you give them a number that's $1 million, then they're going to say, okay, well, $1 million is where I'm going to start, okay, and then where am I going to end up? If you give them a number that's $3,000, they're going to say, okay, $3,000 is where I'm going to start. They're not going to end up at $1 million. I mean, they could, but it's a lot more difficult for them to get there as opposed to the jury trying to come up with numbers themselves. I think also the juries think medical care is really expensive, and it is most of the time, if you have to pay for it in cash as opposed to with insurance. And so if they had to come up with their own numbers for what they think something costs, it could be a lot higher than what your bills actually show, especially if there's insurance or something like that involved.
Yeah, the more I think about it, the more I think we should, in maybe even the majority of our cases, not just when there's tiny medical bills, not submit the medical bills. And the one issue I see is you get that one juror that doesn't really like giving money. And that juror will indefinitely, we already gave them the medical bills. What else do we need to give them? We don't need to give them much more. And you get those, like, even I've seen, $100,000 in medical bills for back surgery, $5,000 to $25,000 for pain and suffering. I mean, you heard enough to get a back surgery. Obviously, that's some real stuff. And I think a lot of those cases, without the money. And the other problem is when the medical bills are too high. And so, you get, depending on the rulings you get from the judge, depending on your briefing, you try to fight this and keep it from coming in. But let's say your medical bills are $100,000, but they're allowed to present evidence that had there been private insurance, the medical bill would have been $30, and if it was Medicaid, it would have been $20, Medicare would have been $25, something like that. And then you're fighting, it kind of throws like a dead fish in the whole case. I mean, it's like it all stinks. Like, why are the doctors charging more? Why is the lawyer okay with this? And so then even if you get those bills, it's already, your jurors already had to fight for you just to get your medical bills. They don't have a lot of chips left to trade when they're trying to get your other elements of damages. So I think that, I can't wait till we get to a point where we just aren't submitting medical bills at all. Be sure, though, and we learned this in this case, to drop your claim for medical bills well before trial so that the defense doesn't try to get them in, because in ours they tried to bring up what the bills were in the hope that they could anchor down. It didn't work, but they tried to go anchor down the number. But they kind of look silly to say, well, the medical bills were only $44,000. How can she have $2 million in pain? And there was no evidence of that because they didn't come in. But I would definitely try to keep them out, try to eliminate them out in most cases. But especially if I had under $10,000 in medical bills, there's no way I'd put them in. And like you said, you have the surgeons talk about the surgeries they did. The jurors are going to assume the bills were higher than that anyway, even though that's not an element. They kind of throw it in there, I think.
We'll return to part 2 of this podcast in just a moment. Each year, the law firm of Cowen, Peacock pays millions of dollars in co-counsel fees to attorneys nationwide. Are you an attorney with a catastrophic injury or wrongful death case you'd like to discuss with host Michael Cowen? If so, you can reach Michael by calling 210-941-1301 or send an email to michael@cowenlaw.com. We now return to the rest of this episode of Trial Lawyer Nation.
I think we've all seen it play out in trial. I had it play out in a trial where I know that the jurors were fighting over, they're fighting for me. I had some jurors fighting for our client. And
some not.
And some not. And it was very evident from the verdict that they used all their chips on the medical bills, because we got the full medical bills and then nothing else and any other damage. And so we sent them back. The court said, well, that's an inconsistent verdict. You need to go back and keep deliberating. And then they came back with suddenly all this money for this that wasn't on the original verdict form for pain and suffering. And I think it was a lot more than I had expected. And based on conversation with the jurors, it was because that was the fight that was happening in the jury room. Is the ones that were for us, they would have given us a lot more, but they were fighting just for the medical bills, and we've seen it happen.
It's an easy compromise. We'll pay their meds, at least put them back to even. Whereas if they don't have that option, then they have to actually look at what are the actual injuries and think about it. And I think you're a lot more likely to get a good number there. But you see that happen in the courthouse all the time. Just the medicals. The medical is plus 5,000. Medical is plus 25,000. I mean, you see it even on serious injury cases. You see it happen all the time. And I think you take out the medicals. Now, sometimes you get $200,000-$300,000 in medical. It's scary to do that. And then some, like, they're over $1 million, so it's not anchoring you down. It's an easier one to do. But those are, how many cases do we really have go to trial even at this point where your medical bills are over $1 million and you have enough coverage and you're trying the case? That's an unusual situation.
Right. So the answer for advice about leaving out the meds, if it's $10,000, I guess the answer is go for it.
Yeah.
Make sure you talk to your client, of course, about it first, and they understand. But in that case, since it looks like all the bills were paid by Medicaid,
Well, the other thing you need to let the client know is that even though you're non-suiting your claim for medical bills, the Medicaid lien still attaches to the cause of action.
Right.
You believe that more likely than not your client's going to be better off, but you should get it preferably in writing that you've advised the client of this, they know the risks and benefits, and they're authorizing you to do this. Just just in case you don't do well. If you don't do well, it's probably not because you didn't submit the meds. It's some other problem with your case, but you certainly don't want someone coming back and blaming you.
Right. So the next question is another question about presenting damages in a death case. So this one says, I represent the spouse of someone who died in an accident. There's no amount of money that will make things right, which we talked about before. So they want to do something that makes a difference. What do you suggest for alternative damage models that bring about some kind of positive change?
Well, if you're talking about, it's really different as to whether you're talking about settlement or trial. If you're talking about settlement, and you can find like a systems failure or safety failure in the case that you could prevent in the future, making a condition of settlement that the defendant do something to fix it. And I'll give you an example. We had a case where we had a tire come off an 18-wheeler, and a 77-year-old woman was driving down the road, tire hit her windshield, broke the windshield, she ended up going off the road and getting killed. The money was not our client's primary motivating factor. She did fine. She obviously wasn't dependent on her mother. The mother actually was kind of dependent on her. The mom was living with her at the time of the death. And she had some guilt about bringing a case and profiting off the death of her mother. Now, we still require them to pay us money damages, but one thing that, with the client's permission, we did that was non-negotiable was the reason the tire came off is because the defendant didn't properly check the inflation, and it was run underinflated, and it just came off. And so we required, and we picked the training video, that the trucking company certify that they give all their drivers this training and that they issue them all an actual pressure gauge and not just use a piece of wood to dump the tires. And in that case, the defendant accepted it, and we got the case settled. And the client felt so much better. We felt like we were doing a good thing. We're trying to save the next life. And so I think things like that make people feel a lot better. If the judge will let you, if the other side, either doesn't object or they object and you can overcome it, talking to the client if you're at trial about what their hopes are for the future, kind of like what would they do with the money if you can. I hope to set up a foundation to do things to prevent this. I hope to set up a foundation to educate children, because that's what he was trying to do. You find some use for the money, some reason for the jury to give money. And if it's real, I think it would be more likely to, if you're suggesting that giving money to your client would be more likely to bring about a positive change, and you've researched it and you found a way to make that admissible, which I could see all kinds of issues in there. I think that's very motivating.
Yeah, I mean, it's to do, to require the defendant to do something to make some kind of change, I think would have to be through a settlement. Can't imagine how it would work in terms of a damages jury charge. So
it can't. You have that has to be done through a settlement, or, like I said, if you could, having the plaintiff say, if I get this money, I would do X with it, and then getting the jury to believe that they really will, and not just go buy a yacht. And again, I'm a little concerned about giving people that advice. I think you need to do a lot of research and make sure that you're ready for any objection that might come from that, because I can think of a few, since that's not particularly one of the elements of damages. But I could also try to think of some arguments for getting it in.
Yeah. I mean, I think we haven't done legal research about this, so we don't.
Yeah.
I don't know legally how you do it, but I also think that there is a risk too of making your client. Making sure your client is believable when they say it.
Yeah, that has to be sincere, because if it just looks like they're making up a story to get more money,
right,
then you're going to get nothing, or almost nothing.
So before I did that, I would probably test it with a focus group to see what a focus group thinks when your client says that. Because just because I'm all on board and I love my client and I know her and I love her ideas and I know that she's going to do it, does that come across?
That means actually getting the client to talk in front of the focus group, not just relaying what the client would say.
Right.
Yeah.
So maybe recording it in some way and presenting it to a focus group and getting honest reactions of what people think when they hear that.
But I think there are many opportunities to do this in settlements. And, Randy McGinn, we had her on one of the earlier podcasts, and she says she does a demand like, we will settle for $5 million if you make this positive safety change, or $20 million if you won't. And the answer to the question their first response tells you who you're dealing with and what kind of person you're dealing with.
Yeah. Okay, I think we've talked about this next question a little bit, but I think we should address it a little more directly. This was from a listener. I had a trial recently with clear liability, but I lost, and so no one got paid. Now I'm wondering if clear liability isn't the only motivation for a jury to pay damages. What motivates a jury to pay damages, and is clear liability not enough anymore? Yeah, I mean, definitely liability is not the only thing that goes into the jurors' minds, even if it's a rear-end collision. If
having lost more than one rear-end collision in my career, I hate to admit that, but it's happened. So I would disagree with the part not enough anymore, because I think it's never been enough. And I think there's multiple factors that go into this. Is one, does your client deserve the money? Is there in the jury's eyes? Do they believe they're really hurt? Do they think they're the kind of person that isn't going to waste it on drugs, alcohol, vices, or some other bad way of spending money, giving it to terrorist organizations? I don't know what it is. But you have to think about that. What is it about your client that would make someone want to or not want to give that person money? Are you presenting yourself in such a way that the jurors don't want to not give money because they don't want you to have it? How do you market yourself? Have you advertised? I think there's a danger with some lawyers that have an advertisement of them walking to the Rolls Royce or getting on their private jet. I don't know if that's the case or not, but I could see a juror saying, "Well, I don't want to be contributing to that." So I think you have to watch how you present how your client presents, how you present yourself. And is the defendant such a great witness where the juror says, "It's clearly their fault, but it's an accident. No one meant this." And so how good isn't just clear liability, but is there any blameworthiness? Which is why auto crash cases are without a company defendant are so hard. And I think you overcome them either by the defense team typically doing something to be villainous and twist things around and hide the truth and try to, either through experts or unfair arguments, do something that could be used to get a jury upset, or the defendant just not taking responsibility at all and showing that they need to be taught a lesson. And sometimes just you have a great client, they like your client, they want to help your client. But when you don't have a catastrophic injury and it's just, you say clear liability, but it's like a rear-end collision, not much property damage. There are tough cases, and you really have to look at why should a juror care? Why should a juror give money? Michael Leeserman's 2 questions. This case is simple because blank. This case is important because blank. If you can't answer both of those questions before you go to trial, you're probably not going to be happy with the verdict.
Yeah.
But there is nothing that feels worse than, I lost one last year where the defense stipulated a liability, and we lost because, my client's MRI 6 months before the wreck was worse than his MRI after the wreck, and he was a horrible witness. He was a tough client to have. And we had to get him out of bed in the morning because he was passed out drunk and stuff like that. It was a difficult case that he didn't make any easier at trial. And it happens. I mean, if they don't believe the defendant should pay money, even if the defendant was at fault for causing the crash, they're not going to.
Mm-hmm. Yeah. And the defendant not paying money is the status quo, right? That's the easiest thing for the jury to do. So you have to give them a reason to want to do something hard. It is hard for them to make someone else give money. I mean, it's, it takes motivation, right? To do something other than what the status quo is and where we are. If they did nothing, we're in the same boat that we were right before we walked into this courtroom. So,
and that's, I think Carl Bettinger calls it the hero's journey, because a hero has to do something hard. It is hard to give money. The status quo is to not do anything. And, the walking in, if you poll the jurors, the person asking for money probably doesn't deserve it. They're probably faking or exaggerating their injuries. The plaintiff's lawyer is probably a greedy person that's trying to present false testimony to make money. And so if you don't present a case that overcomes that implicit bias, I don't care what they tell you in jury selection, 95% jurors have some of that in them. And there are very few people that go into trial thinking most people in lawsuits deserve lots of money. That is just not, in this day and age, not a commonly held belief. There are some people that aren't totally against someone getting money in the right circumstance if they deserve it, but the default of everyone getting money is not there. So you have to somehow have a story and have a client that motivates people to say this is important, there's a reason for me to do this, or they're just not, either not going to do it at all, or they're not going to do very much.
One of the things I think we wanted to offer with today's podcast is, I don't know if a model is the right word, but some ideas about how to develop damages in all cases. I think that this can apply across the board depending on what the damages are. It can be in death cases, it can be in catastrophic injury cases, but it can also be in injury cases, right? Where someone has, soft tissue injuries. So I think, Michael, you've done a lot of thinking about this recently and in preparing for a few trials lately that didn't end up going forward for various reasons. But
yeah, I've done a lot of thinking. I was supposed to be in trial this week, actually, and then, resolved late last week, right before we were going to start. And then you and I had another trial we were getting ready for that, unfortunately, the day we were supposed to pick a jury, the judge decided to give them more time. Frustrating, but that's the life of a trial lawyer. And I'm actually trying to write a book, which I may or may not get done someday, so I've been putting thought into that as to, what are we trying to do? So the first thing, I think, before we talk about damages, I don't think it's enough just to present our clients' harms and losses in a vacuum. I think we have to think of where do our clients' harms and losses fit in to the greater story of the trial. And so I have what I call an ideal trial story. What I mean by that is you're not going to have this in every single case. You're much more likely to have this with a corporate defendant that made decisions that led to the crash or whatever the incident was that caused injury or death. You're less likely to get all this in a regular car wreck case, but this is, to me, the ideal story that we're looking for in every case. So I see it as kind of a 3-act play. I've been doing a lot of study because people think in stories. We always have, and there is like a traditional story structure that's been around probably since people were around a fire before they had houses, tens of thousands of years ago. And so in the ancient Greeks, I forgot, was it Aristotle? I forgot who it was, but one of the ancient Greeks set up like a 3-act structure of a play. And so the first act is kind of the setup of the play, of what's going to happen. The second act is confrontation, and the third act is resolution. And there's been a lot of analysis that most stories, especially stories that talk about the hero's journey, which is, again, something that's reflected over and over and over again in movies, plays, literature, follow this kind of basic structure. So I look at the setup is, and we got to remember, it's a juror story. It's not our story. It's not our client's story. It's the juror story. It's the journey that they're experiencing. The trial's about them, not about us. So it starts off, what's the setup? What's Act 1? What starts when they get the jury summons? You have normal people in an ordinary world that are being pulled out of that world to this foreign legal thing that they know nothing about. And you feel very powerless because you're told you have to be there, you're told where to sit, you don't know the rules, they're using a bunch of words you don't understand. But luckily, pretty early in the story, you meet a guide. And hopefully it's going to be one of us who's going to be that trustworthy guide who's going to introduce you to this world and start giving you the tools you're going to need to navigate this world and actually do something while you're there. And that trustworthy guide better be you and not the other lawyer. And then you encounter the villain. And so in our telling, in our opening statement, and I think when we start presenting evidence, we need to show what did the defendant do wrong, but more importantly, how far back were they doing it wrong? How much can we show that they knew they were doing something dangerous and chose to keep doing it anyway? If we can. I mean, not every case has that, but it's what we're always looking for. So that's Act 1, is that, they've been pulled into this other world, they've met their guide, and they're being shown that, hey, there's someone out here doing something bad. They either have already hurt people or they have the potential to hurt people. They don't care, but frustratingly enough for the jurors, they have no power to stop it. Right now, they're still just observers. Act 2 is confrontation. So Act 2, we start with what is the thing that caused harm? What is the incident in our case, the crash, the explosion, the fraud, whatever it is we're trying the case about. And then once we show kind of that they're blameworthy and that what they did wrong, then we go into what are the effects of that. So the life disrupted. And so that's when we start talking about what our client had before, what they loved to do before, their harms and losses, what they're left with. and then hopefully we get into at some point the hope for, with the jurors' hope, what they can do in the future. And after we show that, then the defense is cross-examining, they're putting on their case. That's really the villain trying to get away with it. And hopefully the jurors see that. Okay, we're struggling because, hey, they're making these arguments. I'm tempted to kind of go with them. And, hey, well, my guide is showing me, well, hey, they're not really telling me the truth. They're not telling me the whole story. But I got to be wary of this. So they've got to struggle with that. And then Act 3 is the resolution. I think it starts with the closing argument of the guide comes back and say, okay, you guys, it's time for you to be heroes. Here's all the tools you need. Here are your weapons. Here are the facts. Here are the arguments. Go in there and save the day. And then they got to go in that jury room, and they've got to do the right thing, and they've got to be heroic and make it right for your client. And that's that's the end of the story is, they hopefully come back with a heroic verdict, and then journey home, go back to their ordinary world, and they're able to explain to their friends, families, coworkers, and neighbors why they did what they did. Because if they can't explain that, they're not going to be comfortable doing it. So that's kind of, I don't know if that has anything to do with damages, but that's kind of the structure where I see damages going into. And so what do we need to learn, is what was the life before, but more importantly, what did they love to do? What brought joy and happiness and purpose to the plaintiff's life before this? Then 2, what did they go through? What are the harms and losses? What are they left with afterwards? What is the pain? What treatments have they endured? I'm using all writing language, right? What is their pain? What treatments have they endured? What limitations do they have? What are the things they can't do or they can do, but they pay a price with pain every time they do them? How do they feel when they have to make the choice between, do I pick up my kid knowing it's going to hurt and I'm going to be in bed for 2 hours? Or do I see that look and say no and the kid doesn't understand? Those kind of things. Mm-hmm. And then, finally, I think the hardest part is, what's the hope? What is it our client hopes to do in the future to get their life better, to get back what they can? And hopefully things that, if the jury helps with some money, I can make my life a better place. And, that's what we kind of want to present at trials, those like I said, what they love to do before, the harms, losses, what they're left with afterwards, and then the hope with the jury's help for a better future. Because if you have that hope for the better future, then there's something to actually fight for, other than punishing the defendant. The reptile talks about the jurors are all in it for themselves. They want to protect themselves and their offspring, don't care about anybody else. That may be true, but I think if we also have, not only do you get to protect yourself, your offspring, your family, but you also are helping somebody else and make a better world. I think that altruistic thing really does make a difference in humans. I love and respect David Ball, but I also give human beings a little more credit than he does.
Trial Lawyer Nation is proud to partner with Trial Guides, leader in continuing education for civil plaintiff and criminal defense trial lawyers, with books, DVDs, CLEs, live webinars, and more. Visit trialguides.com and use code TLN19 at checkout to receive our exclusive podcast discount on any Trial Guides products. That's TLN for Trial Lawyer Nation and the number 19. Discount expires August 31st, 2019. And now, back to the show.
I think there's kind of a different worldview for a lot of millennial jurors that we've at least seen on some of our jury panels. I haven't done any study on this, and I don't know whether there's any, scientific basis for this. But it seems like there is not just wanting to protect themselves, but wanting to protect the world as a whole that comes from some of the millennial jurors too. So I think that is a motivation.
I think millennial jurors have more of a heart. I don't think we should be scared of them, but I also think they see bullshit real quick. And they do. I think some of the old school, I don't know that it ever really worked, pump your chest advocacy, I think it's really turn off a lot of jurors, but I think especially, millennial jurors have just seen so much fake stuff, and you got to be really real with them.
Mm-hmm. So I think I'd like to talk a little bit about how do we find this information? So we talked about we need to know what their life was like before. We need to know, the harms and losses, it's different for every person. So how do we find it?
Well, you actually are in the trenches more than I am. I'm blessed to do what I want to do most days. It's taken a long time to get there, and a lot of what I like to do is the theory and the strategy. Mm-hmm. What do you do? Because like I said, I do this too, but you do a lot more of the spending time finding the stuff out, and you do a great job of it, which means I don't have to do as much of the legwork. So what do you do to try to find, let's start with what they love to do before, And then the harms and losses. Kind of what is the process you go through?
Yeah, it's a process that changes for each client, right? Everybody has a different way that they like to tell you about things, or you can get to know them. Some clients are really comfortable in their home, so you go to their home and they show you what their home is like, and they show you their photos, and they talk about their family, and you see their kids running around, and it helps you come up with questions for them. And other people are just like, I don't know about you coming in my home. I don't know about this. Can we just meet in your office? I don't know. So you kind of, I think you start with what is your client most comfortable with, and you start with just meeting them as much as possible, talking to them on the phone, meeting them in person, meeting them, having lunch together, going to their house if they'll let you, going to their mom's house if that's more comfortable for them, and then just asking questions about their life, just being the kind of like a journalist. You just ask questions until you have figured out what the story is. You don't go in thinking you know the story, and so you start by asking about their friends, about their family, about what do they do on the weekends, what do they like about their job. And for some people, that's that they make money. But for other people, it's that it gives them a sense of purpose or accomplishment or other things like that. But really spending a lot of time with the clients is how you get there.
Yeah.
And asking as many questions as you can. And taking what they're, clients don't know what you're looking for. I mean, they don't know how to tell these stories. They don't know what the good stories are. Not that there's bad stories necessarily, but they don't know what you're looking for.
There are bad stories necessarily, and we've heard some.
Well, there are bad stories, but, and there's things that, you just shouldn't say in front of a jury. That just, but, I think spending the time, so some clients, they're visual people. They can't figure out how to find the words to tell you how they feel or to tell you about their stories. And so sometimes you start with those clients and you say, bring me all of the photographs that you have of you and doing whatever it is you're doing. If they're selfies, mirror selfies at the gym, if they're photos of you and your kids at Schlitterbahn, if they're photos of you and your wife, jet skiing in the ocean, whatever it is, bring me all of your photos that you can find. And then we just sit there and we go through photos and we say, what is this a picture of? And then they start telling you about the picture. What is this a picture of? What were you doing here? What is this about? And it gives you a bigger... People take pictures of things that are important to them.
Yeah.
They don't take pictures of things that aren't important to them. And so that gives you a really good idea of what is important to this person and what do they love.
One thing I've learned recently is, and it's a patience thing, is, I've started from the very first time I meet somebody is, what did you love to do before this? And my first instinct is when they start talking about something that I think they can still do, is say, no, tell me what you love to do you can't do anymore. No, I need to find out all the things they love to do because I need to get a complete picture of the life. And there may be ways that it's affected I didn't think of before. So I have to, before I jump to how are you affected, I really need to get the picture of what is your life like before, what did you love to do, and not cut them off when it's something I don't think is going to lead to where I want to go for the case. And that's been a tough lesson for me, but I think when I've done that, one, it gives you not only the more complete picture, but every time a client starts opening up to you, you cut them off because it's not helping the case, then, oh, wait, you only care about the money, you don't care about me. Mm-hmm. And I think it inhibits the communication.
Yeah, I think that's right. I think patience is a big part of it.
Now, you also, and both of us have done work with psychodrama. Does that help in discovering the life before and after?
It does. So there's one kind of caveat to using psychodramatic techniques with clients. There are some clients that are so damaged that it does not work, and it puts them in a worse place emotionally than where they started. So unless you have someone that's a licensed psychiatrist or psychologist that can help you with it, you just tread lightly if you're going to do it yourself.
Yeah,
right?
I think especially with brain damage, PTSD, deaths, we need to be very careful. I
Right.
totally agree with you on that.
But I do think that psychodramatic techniques work really well with clients with all kinds of different injuries. So it takes a long time to use psychodramatic techniques because it's about seeing what the life is and acting it out, going back to those times, reliving things. I mean, it's not something that you just sit around in a circle and you talk about. It's actual involvement, and it takes real involvement from the lawyers for it to work effectively, I think.
Yeah, and I think it needs to be done early, because one good thing when you reenact scenes from someone's life in psychodrama, part of it is you have people kind of act out the roles of the different people in the scene. If you can do that early enough, where then you can go and interview them, find those people, interview them, and see if they could tell the story, so your client doesn't have to tell all the stories themselves. Because I think the client is the worst person to tell stories generally in the courtroom, other than the story of how I'm doing everything I can to get better, and how I'm not going to let this beat me, and how I hope to have a better future, and how great my life was before. To some extent, those are the stories that clients can tell credibly. Stories of harm, loss, they're getting money, or they're hoping to get money, they have no credibility. So, when we can, sometimes you can find some really good witnesses if you do the psychodramatic, discovering the story. And I don't even want to say true psychodrama, because actual psychodrama is more for treatment. This is more like discovering the story using psychodramatic methods. It lets you discover who these other witnesses are, and then go back and find them, and talk to them and see if they'll back you up.
Yeah.
And the other thing to do is, what we did currently is the client that says, I don't know anybody. When we go, what did you love to do? And you go through those things. Well, who did you do those things with? So we had a client, well, I don't know anybody. Well, one of the things you love to do is play basketball. Yes. Who did you play basketball? Well, this other guy. Well, who is he? Well, he's my friend. Well, how long? With 30 years. Well, well, how about work? Oh yeah, no, we worked together for the last 15 years too. And it found out, we found these people that, knew him, he just didn't think of them, and part of it, he had a brain injury, he just didn't think well. But a lot of times, until you go through what they loved, who they did those things with, and then you start meeting those people, then you can really get a good picture from the outside, and a credible picture. Because the less likely it is a juror thinks they're getting a cut of the money, the more credible they are.
I think, too, if you just go to your client and you say, give me witnesses that know about your damages, they don't know what you're talking about. They think that you mean doctors, or they think that you mean their wife, or someone that knows every single medical visit that they had, and that have been with them every single day since it happened and from before, and that's a limited number of people for everybody. I mean, there's only so many people that know every aspect of your life, so that's what they think you mean, right?
Exactly. I think because I think coworkers are some of the best witnesses, and I've seen so many people say, but I haven't gone back to work. They don't know what I've been through. It's like, yeah, I know, but they know what you were like before, and that's still. When, let's say, the defense is pre-existing condition, well, when you have a coworker talking about how great you worked before and you didn't have any problems, that is so credible. It's even better when you have the coworker say, yeah, they came back to work, but they couldn't but I didn't want them to get fired, so I covered for them by helping them, by picking up the big things for them and stuff. That's even better. But even if you don't get that, I mean, just having those other people there, the people they played pickup basketball with, whoever it is, even if they could say, I used to play basketball with him, now I haven't seen him for the last year. But talk about how he could play basketball and all the things he did and how much he enjoyed it and how he didn't have any physical limitations before. I think that's really worth discovering. But again, back to our common theme from this, it takes time.
Yeah, it takes a lot of time. I mean, and kind of what you were saying before is if you cut off a client and you say, I only want to know the physical things that you did before, or I want your hobbies. That's the worst question you can ever ask anybody. Whenever someone, is asking about hobbies in a deposition or something, I'm just thinking, God, what is this? Speed dating? Like, if anybody ever asked me what my hobbies were, I'd have no idea. What are my hobbies? I don't know, because hobbies aren't necessarily something you do all the time, and they're not necessarily the most important things in your life or the things that you love to do.
Yeah.
And some things you might not consider a hobby. Like, for example, we have clients that every year they take a family trip to the river and they all go tubing and it's so much fun for them and it's one of the joys of the summer that they all look forward to. Well, you don't really consider that a hobby because you don't do it all the time and it's not like woodworking or something. But it's something that's super important that they are going to miss out on now that they don't get to do, and you wouldn't discover that if you just said, what are your hobbies?
Yeah, because people ask me what my hobbies are and I don't know that I have any.
Yeah. I mean, it's a weird question to ask people, and so I would suggest to people that they don't start the conversation that way, because I don't think people have a good idea of what hobbies are, and especially for people that are working a lot, or there are things that they do for pleasure and for joy, but maybe they don't call them hobbies. I mean, because they don't, for whatever reason.
Yeah. So I want to ask you, I've been thinking about this a lot, and so doing this right takes a lot of time. We don't all, though, have choices. You and I are now getting to the point finally in our careers we have a choice on how many cases we have. Most of us, for most of our career, don't actually have that choice or don't realize we have the choice. If you work for somebody and you're assigned a docket of cases, there are a lot of firms where you say, well, you gave me, say 80 cases to work on, and I think I should only work on 6. Well, your choices are unemployment or figuring a way to work on 80. So what do you do then? I mean, to do it right takes so much time, but we often don't have that amount of time to put on every case. What do you do?
Yeah, some of the strategies that you can use to help sort of expedite the process, I guess, is, you don't want to wait until the very end, like the day before trial, before you're meeting with witnesses. But, if you have a really good idea that this is a case that's going to go to trial, I mean, you can put a little bit more focus in that case, hopefully more than 30 days or 60 days, whatever the discovery deadline is in your case, just in case you get new witnesses or new information. But even if you just set aside time during depo prep, you have to prepare them for their deposition anyways, I would hope. And during that time, just start the conversation. I mean, you don't have to sit down and have this conversation all at once. It can be, by the way, we're meeting for your deposition tomorrow. Can you bring me any photos that you can find? And start there. Look through their family photos. And, I mean, that takes 20 minutes to look through them and finding things that in the photos that you might want to ask them about. So they send you a photograph of them camping. Ask them about the camping. I mean, maybe they don't go camping all the time, but maybe in that conversation they'll tell you about something else that could trigger it. So one way is through depo prep. You've got to spend time with them anyways to make sure that they're prepared for deposition. That's a good time to do it. I think some of the time you can't avoid. So, I mean, there is some amount of time that it takes to do this right. So if you're going to trial, if you want to do it right, you have to spend time with your clients. I mean, and their witnesses. I mean, there's just I cannot imagine a way around that, because you have to know what they're going to say. You have to know what stories they're going to tell. You have to know how they're going to tell them. If someone goes into court and says, wow, I'm in pain all the time, that doesn't mean anything to a jury.
Yeah.
That pain to one person is different than pain to another, but if you can talk about the limitations and you can describe the pain, you can say it's sharp and it's shooting and it feels like there's fire ants all over my knee and it feels, that means something to people, but it takes time to get people to describe stuff in that way.
It does. I think one other thing is just look at your docket. And, they talk about the Pareto principle, the 80-20 rule, that 80% of results come from 20% of your work. And then I heard Chad Dudley and what's DeBosier's name? It's Steve DeBosier gave a speech, and they talked about they looked in trial work, and actually more than half of your results tend to come from the top 5% of your cases. And we've gotten charted that in our firm, and the years we've made money, that's been very true. The top 5%'s always been more than 50%. The top 20%'s always been more than 80% of the fees. In the years, and when that hasn't happened, we typically haven't done very well that year because we didn't have the hit we needed. And so really look at your docket, and if you don't have time to do it all, then say, okay, these are my 5 best cases. And so I'm going to make sure on these 5 cases that I am going to do it all on these 5 cases. And I'm going to do my best on these other cases, but I want to make sure on my best case of my docket where I can make the most difference, I'm going to put in the time. And then hopefully when you do that, you get better than average results in those 5 cases, and then you can develop your practice where you can do less and less of the bottom 80% type of cases and do more and more of the meaningful cases. But you have to work up to that. And like I said, you don't always have a choice when you're working for someone else, they give you a docket. And frankly, people that worked for me 10 years ago had a docket with too many cases. But I think learning to be selective then, say, okay, I can't do it all in every case, but these are the 5 best cases in my docket. I'm going to make sure that I'm going to do it all on those 5 cases and get spectacular results on those 5 cases. And then also just be a little brutally honest with yourself. And when you realize in discovery that this is no longer one of your 5 best cases, to move it down the list and not continue to put efforts in a case where you're probably not going to get liability, or they caught your client working with a sledgehammer when he said he couldn't work anymore, which we've seen happen.
Yeah.
And not that you necessarily give up on the case, but you just say, okay, we need to dedicate my efforts where they're going to bear the most fruit.
I think one other strategy, and we do this here, every case we approach as a team, right? We have a paralegal that's on the team at least. Sometimes we have other attorneys that are on the team. It just depends on the case. But if you have a legal assistant or a paralegal or a secretary or receptionist, someone that is also talking to clients, if they know what your goals are, we can all be fitting these goals into every conversation that we have with the client. And so that we're all so other people can be gathering information for you. So maybe there's not every single piece of information you can gather for yourself, but they can get you started, right? I mean, they can get you photographs. They can get you a preliminary list of witnesses. They can get you, get the client thinking about what it is that you want at the end of the case.
Absolutely. And even though, just ask the client who are your damages witnesses, aren't going to get you the best witnesses, better than not getting them, not better than having none. And so you do the best you can with the time you have.
Right.
But it's a lot more fun when you have the time to do it right.
It's
a lot more satisfying.
It is.
But to do that, you have to say no to a lot of stuff.
Yeah. Oh, one of the challenges that I've always, just as a side note, that I've always had with this is you want to be engaged with your client and you want to really listen to their stories, but you're not going to remember every single thing that they say. And so I always have a hard time finding a balance between taking notes about what they're saying and being engaged in what they say. So one of the strategies that we use is we put up these big Post-it notes on the wall, and as they're talking, we're all writing it together, and they're participating and writing my notes for me. And so they'll sit there, and we're all talking, and one of the witnesses will say, you didn't write this, or no,
Yeah.
We did that on a case, and that helps so that you can still stay connected with the client, but you have to write it down. I mean, don't think you're going to remember every single thing that your client says.
Absolutely not.
And you want to be able to go back to it and look, and as your strategy changes, or as you meet other witnesses, you can go back to where you started and say, okay, is this the same story I thought it was? Maybe it's not. Maybe this is not the witness that I thought that they were going to be. Okay, let's circle back and figure out, where we need to go. So that's a challenge that I've always had, because I'm the type of person that when I'm engaged. I'm there with the client, and so stopping to take notes, I struggle with that personally.
Yeah,
but
absolutely. But your big note things are really helpful.
They are. But getting the client engaged and taking notes with you, I mean, that helps, because then you're all engaged in it, and it doesn't feel, for me, I don't want them to feel like I don't care about them, or I'm just, writing down whatever, or doodling or something like that. I don't want them to think that.
Yeah.
And so that they can see what I'm doing, and they can be more helpful when they see what your goals are and they see what you're doing. So, we take a big piece of paper and write, X client, what did he love to do before? And we write it really big, and then we're all looking at the question, and we're all thinking, what did he love to do before? We need to fill this big piece of white paper with things that he loved to do before.
And all of a sudden we have multiple pieces of white paper filled.
Right. And so the visual helps with a lot of clients.
Mallory, we could talk about this for days, but I think we're running out of time. So, listeners, one, thank you so much for listening. When we started this a little over a year ago, I had no idea if anybody would ever listen to it, and it is so satisfying to see the numbers and to get the feedback. And please keep sending in questions. We want to help to the extent that we have anything useful to share, anything that you'd like to know that, where we could add any value to your life, in your practice. Please, continue to send in those questions, and we will do our best to answer them. Thank you guys a lot for listening, and we'll talk to you next time on Trial Lawyer Nation. Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you're a regular listener, be sure to visit our website, www.triallawyernation.com, to opt into our mailing list and stay updated on our new episodes. And if you have a Facebook account, send us a request to join our private group called Trial Lawyer Nation-Insider Circle. This exclusive group will allow you to hear about our podcast before they air, interact with the show, and get a sneak peek at some of the behind-the-scenes moments. If you're not on Facebook, you can always contact us via email at podcast@triallawyernation.com. I love to hear from all of you, so please continue to send us emails. Thanks for tuning in, and I look forward to having you with us next time on Trial Lawyer Nation.
Trial Lawyer Nation is proud to partner with Trial Guides, leader in continuing education for civil plaintiff and criminal defense trial lawyers, with books, DVDs, CLEs, live webinars, and more. Visit trialguides.com and use code TLN19 at checkout to receive our exclusive podcast discount on any Trial Guides products. That's TLN for Trial Lawyer Nation and the number 19. Discount expires August 31st, 2019. We look forward to talking with you again soon as we continue to explore powerful insights from our amazing host and remarkable guests here on Trial Lawyer Nation. Until then, please be sure to subscribe and review this podcast on iTunes or your favorite listening app so we can continue to reach more listeners. Visit us at www.triallawyernation.com to send us a message, listen to previous podcasts, or learn more about Michael Cowen and our guests. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our hosts, guests, or contributors and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.